Hi, thank you so much for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jake Blake, an Ohio construction lien law expert. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Jake Blake.
Thank you, Jesse, for the introduction. Um, I'll have to think carefully about the fantastic and the expertise, and maybe those who view the slide or perhaps some of my other presentations on this subject can come to their own conclusions in that regard. But nonetheless, I appreciate the introduction, and hopefully the materials we're going to go over during the next few minutes will be helpful. So here's the quick agenda. We're gonna, and some of this material is overlaps with some prior presentations that we've provided. Um, but it's always good to brush up on the status of the law and and the status of liens from time to time, because unless you're someone like me, you don't spend every day thinking about this kind of stuff. So we're going to talk about what is a lien and how does it work. We're going to talk about some of the basic rules in Ohio. We're going to talk about the steps that occur or what you should be doing after you record your lien, and talk a little bit about what it is you can do to get paid or make the likelihood of payment higher. And then we're going to talk a little bit about what happens, sort of the next move after you've perfected your lien, recorded it, and then the other side has responded with a bond. And then we're going to have a little time for questions, if any. Let's go to the next slide. So, very general, right? What is a lien? You hear that word a lot, right? I'm going to lien the property, but what is it? What does it really do? Well, what it does is it encumbers or puts some restrictions on the property where you performed the work or the project occurred. It creates a cloud on the title, right? It kind of shades the title. It encumbers the title, and it can and usually will prevent a sale or refinancing of the property unless that cloud is cleared. And so it's typically because of that reason, it's typically a default on most mortgages. So if the property you're doing work on is under a mortgage from a bank, a lot of times the banks, as the sort of secured lien holder on that property, will want that thing cleared right away. And if it isn't cleared, it could be a default under the mortgage. And one of the things that can happen on a default is the note holder can say, "Hey, we're going to accelerate, pay everything off right now, or we're going to foreclose." That would be an extreme remedy. I've not seen that happen, but it is a technical default, and that's one of the levers that can be pulled when you do lien a property. And then probably more importantly for most people listening to this presentation, it's almost certainly going to be a default under the contract between the owner of the project and the general contractor. Virtually every construction contract I've seen always includes a rep or warranty or some sort of requirement or obligation to keep the project and the property free and clear of liens. And so when you lien, you notify the owner, obviously, and the next thing the owner is going to do is usually talk to the GC and say, "Hey, clear this up." Now, if you are the GC and you're liening a property, that's a different story, and usually indicates something far more severe is going on if the owner isn't paying the GC. But in general, when you lien, the owner is going to reach out to the general contractor and ask for that lien to be removed. Finally, back in the world of banks, right? Most projects have some sort of construction funding. And a lot of those documents, a lot of those contracts require liens to be cleared, right? Because people, I mean, just think about it. People loaning money into a project don't want to be loaning into a project where there's a dispute over work that was done, payments that were made, and certainly don't want to be loaning money if the money is not going downstream to pay for work. So uh, you can kind of see lurking there in the definition of what a lien is, a lot of the problems that liens cause to owners and general contractors and lenders. Next slide. So basic lien rules, we've covered this terrain to some degree in prior presentations, but like I said at the outset, it's always good for a quick refresher. Notice to owner within 21 days of your first work or delivery of materials to the site. We call that a notice of furnishing here in Ohio, but it has different names in other states. And there are some exceptions, meaning if the owner hasn't, um, posted or filed or served the right notice to commence, you're in some degrees, you're some ways alleviated from having to provide the notice to furnishing, but it's a very simple document. And uh, you know, rather than try to split the atom and figure out whether or not you need to provide a notice of furnishing or not, it's just best practice to just always do it. That way you're covered and you don't have to think about it anymore. Um, I've seen it happen before where subcontractors think, well, I don't need to provide a notice of furnishing because of this, that, or the other, and in fact, that turns out to be incorrect under the law. So better safe than sorry, and this really is the definition of an ounce of prevention um, uh, prevents a pound of harm. The next thing you want to do is you want to timely record your lien. So let's say you've completed your work, or during the course of your work, there's a dispute over payment, and you feel you're entitled to a lien. You're on the clock. You have, and I've got there the days: 75 days for commercial projects, 60 days for residential projects. And we're going to talk a little bit about, again, best practices in this regard in a moment. Um, but once you finish your last work, uh, you have uh, you have either 75 or 60 days. Now, the problem here comes in, how do you define last work? And sometimes that's contractual. Sometimes the contracts will actually say when the last work or what counts. It's important to note that in general, warranty work will not restart the clock. So punch list items, everything prior to final completion typically will be considered the last work. Um, but let's say 2, 3, 4 months later, you have to come out and do some warranty related work that will not restart your clock. Now, you could lien for that warranty work, but you wouldn't be able to go back and attach a lien in connection with the work you provided on the project prior to the warranty work, because after 3 months, your clock would have run. So that's something just to be wary of. And then what usually happens, or what can happen after you lien a project, is you will get a notice to commence suit. That is a notice from the owner, typically, or the general contractor, where they say, okay, we've got your lien, we disagree. You have 60 days to file a lawsuit to foreclose on this lien. And if you don't, your lien uh, is discharged, becomes ineffective. And so you need to make sure you note the date when you receive such a notice, and again, start contemplating how you want to proceed. That's usually a sign from the owner or general contractor that they are interested in fighting the lien and are simply not going to capitulate. Um, if no notice is served, your lien can just kind of exist you know uh, in La La Land for up to 6 years. But after 6 years, the lien expires and will become ineffective. Uh, and then the last point here is kind of a general one, and I see this all the time. I would put this under the category of rushing to failure. A lot of times, you'll see liens that are defective on their face, and Ohio's lien regime, like a lot of states, is very specific. There's very exacting standards for what you must do to successfully record the lien, identify the property, identify the owner, properly serve the lien, the timing involved, which we've already discussed, the amount that you're claiming on the lien. And if you mess those things up, if those things are done improperly, you've essentially recorded an improper lien on a project. You've improperly liened a project. And one of the things that an owner or general contractor can do to respond to such a lien is they can say you've improperly put a cloud on the title on the work. You've slandered the title, and so look, innocent mistakes might generate a claim for slander of title. You misspell the name of the owner or something like that. But if you intentionally do something like intentionally overstate the lien amount or the amount that you're trying to secure, you could be found liable for slandering the title, and that's one piece of leverage that you don't want to have to give the other side. So be accurate on your lien. Don't overstate your claim. And the lien itself, whether the lien is $1 or $5 million, still it has to be cleared generally before a sale or transaction or loan occurs. So there's no benefit really to you by overstating your claim. Next slide, please. So, this is a little disappointing, right? But what happens after your lien? Nothing. You've liened the property. It's on there. You served it. The owner knows. The general contractor knows. Nothing immediately happens. And, sometimes you run into situations where you lien a property and the owner simply doesn't care because either they own the property outright or their funding sources for the project or the property don't care that there's a lien, and they have no plans to sell or transfer the property in the near term, and so the lien itself doesn't do anything. It doesn't force them to do anything at all, and so that is certainly something that can be dissatisfying, right? You've maybe hired an attorney, you've gotten them help to put together the lien, you've analyzed your work, you've realized there's a dispute about payment that you're owed, and you file and record this lien and you serve it, and then nothing. And so that's the rare circumstance, but it does happen. But typically, like I said, there's usually, and it's usually the banks, usually there's somebody applying pressure to get the lien resolved. So go to the next slide. So once you file your lien, it's up to you to kind of take the next step to enforce your rights. And the way you do that in Ohio is you file an action to foreclose on your lien. Again, usually this is a default under a mortgage, and so you're going to get the attention of the owner because the owner is going to have the attention of the banks. The foreclosure action is similar to just a regular breach of contract action. It would be essentially you're going to be making the same arguments that you would if the owner just simply didn't pay you and you didn't lien. And in fact, often, every time, in fact, I've ever filed one of these, you file along with the foreclosure action, you file a breach of contract action. Owner, general contractor failed to pay me as provided underneath the terms of our agreement. And so, there's not like, oftentimes you get clients who are like, can we just go faster, right? Like, why can't I get paid? Unfortunately, if you have to go the litigation route, you're looking at a generally a protracted fight over the amounts owed. So there's no magic or silver bullet here that it allows you to accelerate. And then here you have the 6 years from the recording date to file your foreclosure action. So you have, and that just goes back to when the lien expires. Obviously, once the lien expires, you can't file the foreclosure action, and your other claims that you may have on the project would be subject to whatever regular statute of limitations apply to that claim. In Ohio, the statute of limitations for a breach of contract claim is also 6 years. So those two kind of run in tandem. Next slide. So one good way to kind of take some of the complexity and nuance out of the lien law, and I said before, right? Always file your notice of or always serve your notice of furnishing. The other thing you can do is just follow a 60-60 rule. So 60 days, no later than 60 days after you perform your last work, you should file the lien. And that takes the analysis out of whether it's residential or whether it's commercial. The 60 days is inside of both those windows, and it also takes some of the surprise or guesswork out of, is this warranty work or is this punch list work? If you just, the regular work that was contemplated under the scope of work in your contract, the last screw you put in the wall to fulfill that scope of work, 60 days after that, if you record your lien, you're going to be fine. And then for the next 60 days, you should try to be as annoying as possible. Send letters, call, email, right? Do whatever you can to be a squeaky wheel, because whoever you put the lien on is also going to be getting pressure from, again, either an owner or a lender to get the lien cleared. And the idea here is to get the other side to start negotiating about how much they're going to pay to clear your lien. And and so if your goal is to just get paid something, then this is a good strategy. If your goal is to get paid 100% of what you're owed, that's a negotiating position that you can typically start with, but it's unlikely in a resolution short of litigation that you're going to get the 100%. And we probably could have an entire other presentation about the strategies for negotiated resolutions and mediations and how to make offers and maximize your returns. But and I'm sure everyone who's listening to this presentation has been in these types of discussions, maybe not in the context of litigation, but just in business discussions. There is a price to pay for certainty and speed, and that's what you're trying to achieve. And then in the 60 days immediately following the lien, is you're trying to get a certain amount, and you're trying to get it quickly, and because of that, you usually are willing to accept a discount on the total amount that's owed. If you're hassling of the owner or the GC is not getting anywhere, and you haven't already obtained the services of a construction lawyer to help you in that process, that's the time to reach out to the lawyer and say, okay, I've filed this, I've recorded this lien, I've tried to negotiate it, it hasn't gone anywhere, I'm going to need some help. And so that's the best opportunity, or that's, I think, the best time to get a lawyer involved if you don't already have one. And unless there's a good business reason to delay on filing the foreclosure action, after that 60-day period, that's really the time when you should start considering, okay, we need to draft an action, we need to draft a complaint, we need to find the right court, we need to file it there and serve it. And that'll usually get the attention too, if the lien hasn't gotten the attention of the owner or GC. The filing of a complaint certainly will. Now, you don't have to file an action. I've had clients who in the past have liened properties and decided to do nothing. Like I said, you have 6 years. The lien is out there, and for whatever reason, they're just preserving their lien rights by filing and recording the lien, but then they elect to do nothing. And and frankly, one case I had recently, we liened the property a year ago, and in the interim between us recording our lien and the present, their bank foreclosed on the property for reasons unconnected with our lien. And the bank then forced the owner into a foreclosure. And at the end of the foreclosure, we got paid some money left over because we were subordinate. We were secondary to the bank, and we didn't do anything. So we spent no money, no time. We spent time. We waited. But we spent no money on attempting to foreclose our lien. A bank did it for us. We didn't know that when we filed the lien. So if there are business reasons, you suspect that if you foreclose, you're not going to get anything, or you have a relationship ongoing with that owner or GC, and you do lots of work, and you're just trying to preserve your rights while you negotiate. And it's not a do or die situation where you absolutely need to get paid within a certain amount of time. Otherwise, you're going to have a major corporate event. Sometimes waiting is okay. Again, talk to a lawyer about that. Make sure that you are within the deadlines that you need to be in. That waiting makes sense. That the lien isn't going to become ineffective for some other reason, like bankruptcy or something like that. And then, one thing I tell my clients when they are filing these liens, I ask them, "You're not planning on going on vacation for 2 or 3 months, are you?" Because you could get something in the mail, the notice to commence suit, which you talked about earlier, and if the 60 days elapses once you receive that notice, you've now lost your right to lien. Again, you haven't lost your right to sue for breach of contract, but you have lost your right to lien the property, which is the frankly the most powerful weapon you have in these types of situations. Now, once you receive a notice to commence, if you receive a notice to commence, and you haven't already done so, that is absolutely the time to contact a lawyer. You cannot represent yourself in these matters unless you're an individual who's just going out and doing construction jobs, under some sort of DBA or something like that. But generally, if the company is the contracting party, the company is the one who's liening the property, you're going to need an attorney. Next slide. So we've talked a little bit about a foreclosure action. So what is one of the things that can happen after you file the foreclosure action is the other side, the GC or the owner, will bond off the lien. They will typically hire a surety, pay a surety to provide a bond for the amount of the lien, unless the bond amount, as I say on the slide, is usually 150% of the amount. So if you file a lien for $100,000, the bond amount is going to be $150,000, unless the project is very, very small, in which case it's double. But the bonded off lien will then, once the party bonding the lien notifies the court that a bond has been obtained, they'll usually submit a copy of the bond or even the original to the court, and then at that point, the party bonding off the lien can move, or the court can do on its own. They can issue a an order discharging the lien. Once the lien is discharged, it no longer has any effect, and that's okay. Your lien is now going to be, it's not going to have a cloud over the title, but your claim is secured by the bond, which frankly is better than no bond, because you don't have to go through a foreclosure to get paid. If you successfully prove your claims, your entitlement to payment, then either the client will pay, the general contractor or the owner will pay that amount out of their pocket, or the bond will pay. But either way, you're going to get paid once there's a bond, even if during the course of litigation that owner or general contractor goes out of business or ceases to exist or declares bankruptcy. That's a good sign, though, right? If there's a bond that has been put on, that's a good sign that there's going to be a fight, right? People don't bond off liens if they're intending to settle for some amount, with one exception. A bond is a quick way for a general contractor to get the owner off of its back regarding clearing the lien, and so especially during the course of a project, if an owner receives a lien, a general contractor may move quickly to bond off a lien just so that they can continue to get paid under the prime contract. Next slide. So that concludes the presentation. That was fast and furious. There's a lot of details that probably could use some fleshing out if there are questions. But I do encourage you to go back and look at some of our prior presentations on Ohio lien law. Those provide a good amount of detail, and including some helpful tips on where to find generic forms that you can use to do things like provide a notice of furnishing, record a lien, and so on and so forth.
Well, perfect. Thank you so much, Jake. You really were incredible. You lived up to the hype, I promise. Okay, as far as the questions, we do have a couple that have come through. So I'll go ahead and I'll direct them to you, and we'll see if we can get through some of them. It says, what happens if a subcontractor files a lien, but the GC has already been paid?
Yeah, so it depends on what type of project it is. So that's usually actually what happens, right? Is the subcontractor liens the property, and the owner says, "Well, I've already paid the GC," and so depending on the type of project, that might be a defense to the lien. That might be a defense to your ability to lien the property if they can prove that they've already paid the GC all those amounts. And so then you just have a claim against the general contractor in that circumstance, but you won't be able to lien the project in those circumstances.
Okay, all right, thank you. And another question that came through, can an architect or an engineer file a lien in Ohio?
Yes.
And the same deadlines apply to them as well, correct?
Yes. Now,
Wonderful.
I do want to just caveat here. We talked about residential and commercial. We did not talk about public projects. Public projects you cannot lien a public project. And the reason for that is kind of like public policy, because if you're liening a public project, what you're actually putting a lien on is the public fisc. You're putting a lien on tax dollars paid by the state of Ohio, or collected by the state of Ohio, and paid by Ohioans. And so there's another process for liening a public project. And unlike with residential and commercial, where you oftentimes see those in the construction industry sort of getting the ball rolling and filing their own liens without getting counsel, when you're on a public project and you're not getting paid, you absolutely need to get an attorney involved as soon as you can, because that process is a bit more convoluted and complicated. It involves making a claim on funds, and what is supposed to happen is the public entity, once they get notice that there's a claim on the funds, they're supposed to establish a trust that is then held for the benefit of the person making the lien or the claim on the funds, and that process is a lot more intricate than the one we've just described.
Okay, wonderful. Thank you for that distinction. And then I think this is the last question that's come through, but it says, can I file a lien against the property if I'm an out-of-state contractor?
Yes. Yep. There's no restriction. You will need to hire an Ohio attorney if you end up, trying to foreclose it. But nothing prevents you from filing just because you're not out of stater. Now, a lot of the places where and we didn't talk about this, a lot of, the question is where you file your lien, and that's the subject of some other presentations that we've done in the past. But generally, almost always, the place where you're going to file the lien is going to be the county, or record the lien, is going to be the county where the project is. And so, if you're not physically located in that county, you're likely going to need to hire some outside support, because most of these rural county, offices of the recorder do not have e-filing. So there are services that help you file in that area, or you can just find any attorney in that area that can help you with that. They also, these little offices, these recorder offices, all have their own rules about spacing and the documents that they need in connection with the lien, and those are little traps for the unwary as well. And if you mess that up on your deadline, and your lien gets rejected because you didn't have the right number of inches at the top margin, and then
Right.
you go back and fix that, and you file it on the next day. Well, now your lien is late, and you're setting yourself up for a quick motion to discharge the lien.
Yep. You got to be really cautious of that, of some of those details. All right, so that is the last question that has come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Let me see if I can get to the next slide here for us now. All right, so here are some of SunRay's resources to help you stay organized. So go ahead and scan that QR code to know your deadlines, secure your lien rights, be able to access all of these resources. They're really, really wonderful and helpful. And please remember, each state has its own unique deadlines and lien laws. So please check it out if you're working in a different state other than Ohio. The document names, the deadlines for filing a lawsuit, filing your lien, whatever it happens to be, are going to be completely different. So please check that out to make sure you're protecting yourself. The next webinar that we have with Jake is going to be Wednesday, September 3rd, Getting Paid Faster with Liens, Bonds, and Contracts. That's going to be at 10 a.m. So please register for free at sunraynotice.com/education. And then if you don't mind, take a minute to give us a review on Google. We really do appreciate any feedback that you're able to provide to us. It helps us better ourselves, our webinars, and helps to get some more of the information out to other contractors and suppliers like yourselves. And with that, that is all we have for you today. Thank you again for everyone who attended. We hope to see you at our next webinar.